judge, give the defense a full opportunity. These were mandates, not discretions. They're conditioned precedents to the declaration of manifest necessity. It simply wasn't followed in this case. It wasn't followed the basic rules of Floyd P., which is when a jury gives a note, you share it with counsel, you listen to counsel, you get their views. We don't know whether counsel would have advised the judge about 27B, or would have asked the judge to ask the jury whether...
Counsel, can I go backwards on that?
Sure.
Because part of I don't know what part of this goes into the calculus, but you have two extremely experienced trial lawyers. No one in that room would ever think, potentially, a mistrial may be declared after Tui Rodriguez is given. There isn't any lawyer that's worth their salt that wouldn't think they might get a mistrial on this. So you know where the puck may be going when it comes to giving the Tui Rodriguez. And you say that there was no manifest necessity for this and no opportunity to be heard. How do we factor in that you've got to know that that's going to be on the table, is that a mistrial? And what obligation is there on counsel to say, hey, before you declare a mistrial, let's talk about alternatives to that?
Let me address that. Judge comes in, deviates from her prior practice where she gave counsel a full opportunity, announces to the defense lawyer there's an impasse, bring the jury in. If your honors would accept the audio video that again the district attorney has relied on, it's about 30 seconds till the jury comes in, but you hear a door open. Defense counsel don't know what's in the note, it hasn't been read to them. They don't know what the judge's intentions are. They don't know whether they'll be invited to come to the bench to discuss it. They have to be surprised they weren't given an opportunity. They hear a door open, the jury could come in 5 seconds, much less 30, and I stand before you with 52 years of trial experience to say no competent defense lawyer would risk the wrath of a judge or jury by interrupting that process, by making objections.
Wait, so the judge said they're at an impasse, bring in the jury?
Bring in the jury, and you can actually hear a door open.
Okay, so and you have 30 seconds to object?
But you don't know that it's not 5 seconds. You don't know the door's not open. You don't know the jury
can say, Your
hear.
Honor, may I see you at sidebar?
In this case, that's happened repeatedly? No?
Here, the defense lawyers did not know what the judge's intentions were. They didn't know what was in the note.
But they did know that the jury had reported to her that they were at an impasse.
They were at an impasse. Bring the jury in. Yes, that was possible, but to
what was possible?
To ask to go to the bench. But
yes.
This court
and did that happen?
No, but neither did it happen with the prosecutor, who this court says has a heavy burden because they're the sovereign. They want to re-prosecute somebody after a mistrial, to subject them to the perils of a second prosecution. The trial court did not impose a burden on the prosecutor. They have more of an obligation in double jeopardy law to raise options to a mistrial. And I don't think it's fair to conjecture consent or to penalize a defense lawyer when they have been relying on a procedure that's lawful, where defense lawyers have a full opportunity to be heard. They don't know what's in the note.
She doesn't need the consent of the defense to declare a mistrial. She needs to determine that there was manifest necessity for a mistrial, correct?
With a careful consideration of alternatives and after giving
So that may explain why, perhaps, the judge did not inquire, was because given, I don't mean to replow the same territory, but this was the third note.
It was the third note, but it was a note that demonstrated, because of the deliberations between the second and third, that the defense didn't want a mistrial.
Mr. Weinberg, are you aware of any cases, or can you let me know if there are any cases where the judge gives Tui,
Yep.
and then the jury comes back and says we're deadlocked, is articulate as this jury was or not, and then the judge does something different other than just declare mistrial?
Well, the statute itself says the judge the judge has no right to obligate the jury to redeliberate, but every right to ask the jury whether they would consent to continue deliberations. And here I
But
contest.
here, the jury said to continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs.
Right, and in the face of that, you think give it the old college try is okay?
I think that the judge had alternatives that the record does not reflect were carefully considered, including, is your deadlock on all three counts? Is there any, would you consent to deliberate on any count that you've not reached an irrevocable deadlock? Questions like that are not coercive. Questions like that would have actually given the illumination post July 1, and I'm not arguing that that provides proof as to what the process was.
Again,
at
in
July 1.
the statutes, again, is it may, correct?
The statute says, 27B says a court may make that request, but the Stewart and Taylor rule require careful consideration. That at minimum was an option not considered.
The careful consideration is basically all that has gone on as far as the length of deliberations, the number of notes, et cetera, and what the notes say. That's part of the calculus, correct?
Yes, the judge made her own judgment, and I'm not saying the judgment was irrational. I'm saying that she would have been aided by counsel. The law required she give counsel an opportunity to be heard. There's no evidence in the record she considered any option except to declare a mistrial. That contradicts the clear jurisprudence of this court, and I contend it contradicts the core protections that double jeopardy give to a defendant against being re-prosecuted, which the Supreme Court has said carries with it the risk that an innocent person can be convicted, the ordeal of a second prosecution. This court has given procedural guidance, conditions precedent. This is what the words are must. 27B may be discretionary, although we argue the reporter's note in combination with Taylor required that inquiry about partial verdicts. This court has told the judges ordering a mistrial is irrevocable. And you need to go through certain procedural conditions precedent, and the judge did not. And I respectfully submit that extinguishes the principal basis to say there was manifest necessity in this case. There was never a knowing and intelligent consent. The defendant never asked for a mistrial. And at minimum, secondly, we strongly ask this court to extend the Sixth Amendment jurisprudence where you allow jury voir dires into the Fifth Amendment. The Fifth Amendment is as important as the Sixth Amendment, and a jury voir dire conducted by an experienced judge can determine whether or not there was a unanimous and final verdict of not guilty on two counts, one of which carries with it a life imprisonment. I thank you very much for the privilege of appearing before you today.
Thank you. Okay, to Ms. Sherrington.
Good morning, Your Honors. May it please the Court, Caleb Schillinger for the Commonwealth. With me at council table is my colleague, ADA Laura McLaughlin. I'd like to start with the mistrial issue and emphasize a point that has been touched on through the questions to my brother, but that I think is important for the Court to consider, and that is the trial strategy here. As a general matter, absent some sort of definite indication from the jury that they're prepared to find a defendant not guilty on a charge, effective defense counsel is not going to ask the judge to start probing, or not going to want the judge sua sponte to do that, because doing so runs the risk of extracting a guilty verdict and convicting your client instead of obtaining a mistrial across the board.
But what do we do with the fact that after the third note, the jury is called in? There's not, unlike the first and second note where she says, okay, counsel, let me know what you think. Here, we don't have that opportunity.
The judge did inform counsel that the jury was at an impasse, and I would argue at this point it is clear that a mistrial is inevitable or unavoidable. The jury has twice already returned deadlocked. The defendant has argued strenuously that they are deadlocked. They've been given Tui Rodriguez, and now the judge informs counsel they're at an impasse. At that point, counsel couldn't credibly believe that the result here was going to be anything other than a mistrial. And again, in addition, just to circle back, All the more so, Your Honor, because of what was their defense in this case. The defendant's defense was that she didn't cause the victim's death, but allegedly had been framed. If the jury were to come back with a guilty verdict on any of the charges, or either of the lesser included offenses, they would have necessarily had to find that the victim did cause, or excuse me, the defendant did cause the victim's death. And it would have been a rejection of that defense in the defendant's public narrative. The defendant here did not want the judge to do more.
Well, rather than speculate what the defense wanted, let me ask you about what happened. Did the judge have either the discretion or the obligation to ask the jury after the last note about continued deliberations or a verdict on any lesser included offense?
No obligation, Your Honor. Perhaps as a matter of...
Did the judge have the discretion to do so?
Rule 27B is discretionary. The language of the rule itself consistently refers to what a judge or a jury may do. I know the defendant argues...
So it's not inherently coercive? If
so
the judge has the discretion, it can't be coercive, correct?
Well, no, it's a matter of discretion, and then consider the factors that inform the exercise of that discretion, and that's what the judge did consider here. On the one hand, the judge had no doubt, based on the jury's notes, that they had not reached agreement on any of the charges. Further, the jury's third note had triggered 234A, 68C, so they couldn't be compelled to continue deliberating. They made it abundantly clear they did not consent.
Unless they want to.
Unless they wanted to, exactly. But indicated that if they were forced to continue deliberating, any verdict they returned wouldn't be a just verdict. It would be the product of compromising their deeply held beliefs and moral convictions. You have that on the one hand informing the exercise of discretion. On the other hand, you have strong countervailing reasons that argued against making further inquiry here, which is the potential for coercion. You have a jury that has sat through a grueling 10-week trial, nearly 100 witnesses, hundreds of exhibits. Now 4 or 5 days of deliberations. They've returned 3 times indicating that they are deadlocked, they are at an impasse, and they do not want to continue to deliberate.
But, counsel, I'm sorry to interrupt you on that because I don't want to miss this point. But wouldn't that go to the calculus of manifest necessity? Because all of those things seem to be the reasons why you would tell counsel about the last note and say, what do you think? Because you have gone through this 10-week trial. You have gone through the impairment process. You've spent a lot of time, energy, and money, anxiety, and angst in this trial. Why wouldn't we talk about what potentially we could do short of saying, mistrial, let's start again?
But certainly, Your Honor, and I think, in hindsight, seeing, the quote-unquote remarkable turnaround of the defendant's position, would it have been better, would it have been preferable for the judge to take that extra step, perhaps, and another judge might have done that. But here, given the progression up to the third note, and in particular, given the defendant's response to each of those 2 prior notes, I think the judge could reasonably conclude the jury is at an impasse, there is a manifest necessity for a mistrial, there is nothing more to be done here, and in fact, in her order denying the defendant's motion to dismiss, the judge did say a mistrial was inevitable.
You can't find consent, right? If you don't ask, the consent is out the window, isn't it?
I don't agree, Your Honor. You can find consent through the lack of an objection here.
Even the burden of proof is on the Commonwealth. There's no opportunity whatsoever for the defense counsel to raise anything. I get you may have manifest necessity, but I don't see how you can get consent when you haven't been consulted in any way.
They were consulted in response to the first 2 notes, and what was the defendant's response to those notes? It was to argue in favor of doing thorough deliberation and accelerate the process at every step toward a mistrial.
But pushing towards a verdict is different from that's different. I mean, they want a verdict. Because they want Tui Rodriguez doesn't mean they consented to a mistrial.
That's my thing.
Even so,
That's
Your
what I
Honor,
keep
they had
saying.
opportunities to object. They could have objected while waiting for
That's
the
my
jury
big
to
thing.
enter the room. 30 seconds is ample time to at least ask, may we be heard at sidebar, Your Honor, after being informed that the jury's at an impasse. They could have brought the issue up again during the scheduling conference after the jury was excused to the jury room, and even after that, they still could have brought it up. I mean, we cited in our brief Fuentes as an example of where a defendant lodged an objection after the fact, after the jury had been excused to the jury room, and at that point, the judge did still consider counsel's arguments. And I think, given the defendant's response to the prior notes, it being clear what the defendant was advocating for here, and at the point of the third note, it being unavoidable based on manifest necessity to declare a mistrial, the absence of an objection here, or even asking to be heard, Your Honor, indicates consent.
You might have, I know it probably is in your brief, but what's your best case for that?
This case is closer to Pellegrin, Your Honor, and very different than Horrigan. So as between the two, certainly where there is something abrupt that happens that is inconsistent with the way defendant has conducted him or herself, the approach that they have taken during the trial, it would be difficult to find consent. Horrigan is an example of that. Judge comes in, abruptly announces, trial judge is unable to preside, I'm declaring a mistrial. There was no indication there that, the defendant was in agreement with that. But here, again, where you have the defendant advocating for the result of a mistrial, the ultimate conclusion of it, when it is then ultimately declared to not...
How do you know the defendant is advocating for a mistrial as opposed to pushing a verdict?
Because, Your Honor, not just what they argue, but what they argue.
Because Tui, there's two results of Tui. It's either a verdict or it's a mistrial, and it pushes the jury to its extreme. So when you say that they're advocating for a mistrial, they could
Thank you. That's what I've been saying.
Advocating the jury for that final push, as the Tui Rodriguez instruction says.
To vote.
You need to check yourself. One side has the burden of proof. It's very favorable in some instances to a defendant. So how can you stand up here and say that they were pushing for a mistrial?
Perhaps as to just Tui Rodriguez, although as a practical matter, as Justice George has pointed out, experienced defense counsel understand that there's not going to be a mistrial before that instruction has been given, or very likely. But set that aside, Your Honor.
Well, I think experienced counsel know that you're most likely not going to get further deliberations, but counsel also know that it could very well, it's a flip of a coin. It could be a verdict or it could be a mistrial.
Right. On top of that, Your Honor, I would point to, in response to the first note, the Commonwealth argued against a finding of due and thorough deliberation. Hasn't been enough time, let the jury continue to deliberate. Already at that point, the defendant was prepared to argue there's been due and thorough deliberation. I think the exact quote is, we believe there's been sufficient time. Disagreed with the Commonwealth's reading of the note from the juror that there might still be the possibility of reaching a unanimous verdict, arguing that they'd already exhausted all manner of compromise, all manner of persuasion. So, and then again, in response to the second note, again argued there's been due and thorough deliberation. Those arguments are pushing to the point where 234A 68C is triggered, and the jury cannot continue to deliberate, and a mistrial will have to be declared unless they consent to further deliberation.
I think it's safe to say that they were pushing for a Tui instruction, correct?
Yes.
Yes, they asked for that as well in response
Right.
to both notes, Your Honor.
Do you need consent in order to win?
No, Your Honor, there was manifest necessity for the declaration of a mistrial here.
And so absent the consent, you can just, you think the manifest necessity existed?
Yes, I don't think that the judge abused her discretion in declaring a mistrial for manifest necessity based on the jury deadlock in this case for the reasons that we have discussed and we discussed with my brother.
But, counsel, we also have, and not necessarily in this context, but we have in cases where there are evidentiary issues, where we have found that the trial judge abused their discretion when they didn't utilize something that they could have. And so in the record here, where there, again, it's not necessarily prescriptive, but there's 27B that says may. There's other things that could have been done short of declaring a mistrial. Is there no calculus here that says that perhaps there could be an abuse of discretion because there's nothing to suggest that she went through the progression of what she could have done short of declaring a mistrial, which directly goes to not giving defense counsel an opportunity to say, hey, we've got all our heads in the courtroom. Let's all collectively think about this, and perhaps we can all come to some other vertical other than declaring mistrial.
Yeah, and I think it's clear from the judge's order that she was cognizant at the time of these countervailing considerations, looking to the jury's notes, the lack of any indication of agreement on the charges, balanced against the risk of coercion, the defendant's trial strategy, and the fact that the defendant had not been advocating for the judge to do something more. I think it's clear that the judge was aware of these considerations and balanced them in a way that was not an abuse of discretion. Might a different judge have reached a different outcome here? Perhaps. But the judge's determination here, which is owed some deference, if not an abuse of discretion, was not outside the range of reasonable outcomes, given the jury's notes and these other considerations, Your Honor.
You don't think it would have been coercive to say, come on, jury, I know you say that you're exhausted, that any further deliberations would force us to compromise these deeply held beliefs, but did you reach a verdict on count one?
I do think that would be extremely coercive, Your Honor, yes. And I would point the court to footnote 5 in Ray v. Commonwealth, where this court said and noted, there may be a prevailing practice among federal courts about inquiring individually of jurors as to whether they're truly deadlocked or perhaps further inquiry, but that is not the prevailing practice here in Massachusetts and is not an encouraged practice, particularly because of the risk of coercion.
I take it Rule 27 doesn't, there's no discussion of Rule 27 at any point during the deliberations or sort of preparing for the deliberations, right? When we read through this whole record, we're not going to find any indication it was on anyone's mind, right?
Correct.
But, so I see your point on the note is so compelling that they've worked this to the end. The problem comes when we get this new information that's somewhat inconsistent with that they've, I mean, the key sentence, some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails. Then we get this motion for a new trial with 4 or 5 jurors saying that's not the case, right? That's the troubling part. What should happen at that point?
And I do want to make sure I get to this, Your Honor. The alleged agreement reflected in those statements is not an acquittal. It lacks finality of a verdict, really for 2 reasons. One is the reason that's already...
I get that point. I'm just trying to figure out what should the judge do at that point? Because they're arguing, okay, you have some follow-up obligation. Is there no obligation whatsoever, I guess, is what...
No, and we argued below, actually, Your Honor, that it's not reliable or competent evidence because it goes to the substance of the jury's deliberations and is being used to try and impeach the declaration of the mistrial based on the jury's notes.
Accepts, the judge makes a finding that she finds them credible for the purposes of this motion, right? So she doesn't say they're unreliable, but rather accepts their reliability and then concludes that nonetheless that she can't inquire here without invading deliberations. That's it's different from reliability. She's given up the reliability point, right? She's made a finding that I accept for these purposes that those 4 jurors or 5 jurors
Correct.
are credible, right? So it's not a reliability issue either, right?
Correct, but the judge also correctly or properly ruled that it would not be appropriate to conduct some sort of post-trial inquiry at this point for a number of reasons. One, this jury, a mistrial was declared, this jury was discharged, they've now been discharged for 4 months. They have no power or authority at this point to come back and render a de facto verdict.
Well, the request is to inquire of them, which we said you can do in Fidler and McGowan et al., right?
But not to get into their deliberations.
But that's a separate matter. You said that, you can't bring this jury back. You can bring them back for post-verdict inquiry.
Well, it's one...
Under the guidance of Fidler, et cetera, right?
It's one thing,
Yes.
Your Honor, to bring a jury back and inquire as to extraneous influences to determine whether a verdict that was returned and affirmed may have been the product of other than a fair and impartial jury. It's quite another to bring a jury back to essentially construct a
And that
verdict.
what Mr. Weinberg argues is what we protected are the Sixth Amendment rights to a fair trial, but he says we should expand our law, as I understand him, to include the Fifth Amendment right and double jeopardy protections as well. What's your response to that? Why not?
I agree with the reasoning of the appeals court in Di Benedetto that it can't simply be the fact that it implicates a core constitutional right to allow for this sort of inquiry. And here, unlike...
Why not? Why is the Fifth Amendment any lesser of a right than the Sixth?
It's not that it's any lesser of a right, Your Honor, but Although it is different than the 6 in that here there's, a balance of 2 competing public policy considerations. It's not simply the defendant's right, there's the public's interest and right as well. So it is different than, for example, the Sixth Amendment right.
Well, doesn't the public have an interest in finding out the truth of what the jury decided?
They have an interest in a just judgment that is in fact a final outcome or final verdict here. But setting aside whether expanding it might be appropriate, it cannot be done in this case without getting into the substance of the deliberations, and I think my brother revealed that under questioning. There are several issues with it. One is, again, this jury has been discharged now for more than 4 months and has been subject to extraneous influences, potentially including harassment.
We've sent
threats.
back jurors on race. I can't remember how many years. It was like a decade later or something. Timing's not going to be a winner for you, is it?
No.
It has to be.
No, that by itself, Your Honor, is not a reason not to do it. I'm raising it as an additional consideration or concern here. But there are others as well, which is, it's not simply a matter of bringing a jury back and trying to ask them a yes or no question. That's not how juries reach verdicts. We ask them to engage in group decision-making, collective discussion, review of the evidence.
But
So it's-
our post-verdict inquiry is guided, and we always say to the jurors, and we tell the trial judges, you have to instruct the jurors, do not tell me about the contents of your deliberations, answer this specific limited question. And the limited question posed by the defense, and I think in the ACLU brief, is did you reach a verdict essentially on counts 1 and 3, or was it acquittal? Right?
I don't know that that was the specific question they proposed, but I understand.
Whatever,
Take Your Honor's point.
However
Yeah.
they phrase it, it's a limited yes/no question.
Yes, and my point is that's an artificial inquiry. Or take, for example,
But we asked,
Did
do
you-
reach it? Have you reached a verdict? That in and of itself is a standard question, right? That can't be crossing the line, right? Or is it?
no, but again, I want to re-emphasize the point that was raised earlier, which is, imagine a juror had tentatively agreed to find not guilty on a particular charge. But that was subject to further deliberation or consideration. Maybe the juror wanted to see what happened with the other charges. You now bring the jurors back and you simply ask them, I don't want to hear anything else, I just want a yes or no. It doesn't give that juror any opportunity to explain that their agreement was tentative at that point. And so it's an artificial exercise to say,
Is that what Bluford, is that Justice George asked brother counsel about Bluford? Is Bluford the answer for you that that's what Chief Justice Roberts was saying in Bluford, that it's always tentative? Or is it's only in lesser included that works? Because I asked Mr. Weinberg, is there a federal case right on point that we can look to? You at least have Bluford. Is Bluford controlling? And it's the Supreme Court.
would argue that it is, and I'd actually take it one step farther, which is, not only is there the concern that was raised in Bluford that the perceived agreement or unanimity here may have been the product of a very early discussion, subject to further deliberation, but jurors are free to change their mind and change their vote right up until the verdict is affirmed and recorded. They could vote guilty, walk into the courtroom, and at that point change their mind and say, you know what, I think the defendant is not guilty. So even if, like counsel wants to argue, this was a final vote, this was a final decision, you still can't rule out the possibility that any juror was free to change their mind had they been required to go through the full exercise of rendering and affirming a verdict.
Can I ask, is their argument what Justice Sotomayor wrote in dissent in Bluford, or is it different?
To characterize counsel's argument, I think that they are relying on that for the notion of there being an acquittal in substance, not form, although if you look at the cases Justice Sotomayor cited for that proposition, they're all cases involving judicial rulings. They're not jury determinations. I'm not aware of any federal authority that supports the proposition that there can be an acquittal in substance but not form, or I guess more to the point, says that a state cannot impose the requirement that a verdict be affirmed and recorded. I think, if anything, Bluford acknowledges that that could be a perfectly legitimate requirement where it said, take the defendant's argument here on its own terms. It wasn't a final result, quite apart from the requirement to render a verdict or a judgment. So I think Bluford does support our case, Your Honor. I just do want to emphasize that it's not only just the possibility that there could be a change of mind during the deliberations itself, but even after that.
Bluford limited to lesser included, or is Bluford broader than a lesser included opinion?
I don't read it that way, Your Honor. No, I read it as the general proposition that there are multiple charges, whether they're lesser included or not. Jurors remain free to go back and revisit a prior vote. In fact, I think the court said that although Arkansas was an acquittal first jurisdiction, nonetheless, the jury remained free to go back and revisit a prior vote because that's what jurors do. And it wasn't inconsistent with the instructions. I want to emphasize one other point, which is, at most, what we're talking about here with these juror statements is a snapshot of the jurors' deliberations, but you cannot short-circuit the verdict requirement and rely merely on such a snapshot. And it's important because it protects defendants, too. You can imagine a different scenario where a juror comes forward and says, notwithstanding the declaration of a mistrial, we all took a vote, and we found the defendant guilty of murder. If the Commonwealth were to come forward and say, effect should be given to that vote, there can't be any serious doubt that the defendant, whether in this case or in a future case, would argue that is not a valid verdict and shouldn't be given any consideration. Unless Your Honors have any other questions, Commonwealth would ask that the defendant's petition be denied.
Okay, thank you very much.
Court, all rise, please.
Yeah, even polling the jury at the end, you don't get their full thoughts because you're not allowed to ask about deliberations. It's just very specific questions. Like, remember during Murdoch when they brought the jurors in? It's very specific questions. So, you can't ask about contents of deliberations, only the outcome.